Good afternoon. 5, 6, 7. We may or may not have a quorum, so we'll go ahead and start the meeting and we'll find out. This is June 4th, 2018. Notice a public meeting for the Child Support Guideline Committee. And I will do the roll call. Kathleen Baker.
Here.
Karen Cliff. Ellen Crecilius.
Mark Markovic for Ellen Crecilius.
Senator Farley. Assemblyman Fumo. Judge Hoskin.
Here.
Nova Murray.
David Castagnola for Nova Murray.
Assemblyman Pickard. Judge Robb. Senator Roberson. Joseph Sanford.
Present.
Judge Shirley. Justice Stiglitz. Kim Surratt. And Don Throne.
Present.
All right, we have 7 present. We need 8 for a quorum. I do have a text message that Assemblyman Pickard is on his way. He's going to be late, so let's give it a few more minutes. We'll see if we have a quorum, and we will continue the meeting at that time. Thank you. If anybody from the committee appears by phone, please announce your presence so that we know we have a quorum. Thank you. For those of you listening on the phone, we are waiting to see if we can develop a quorum. Otherwise, we can't hold the meeting, so we're going to wait a few more minutes. Thank you. Okay, for those of you listening on the phone, one of our committee members has stated that he is 3 minutes out from arrival, so we will have the meeting as soon as he arrives. Thank you. All right. Let's reconvene this meeting. As I see, we have a quorum now. Assemblyman Pickard has just joined us. And that gives us a quorum.
Thank you, Madam Chair. I apologize for my tardiness.
No worries. Thank you for being here so we could conduct a meeting. All right. We will move on now to public comment. Is there anybody in Las Vegas that would like to give public comment? Seeing none, is there anybody on the phone that would like to give public comment?
We do have.
Oh, you do?
Madam Chair.
Okay. Come on up to the table. You have a microphone in front of you with a button, and you can have a seat and introduce yourself. And once you do that, I will time you. You will have 3 minutes to give your public comment. I am rude. I do cut you off at 3 minutes, but we do it to everybody. So if you'll start with your name, please.
My name is Yolanda Dias, but I don't know how you could help someone or know what's going on with them if you cut them off in 3 minutes. Because I'm not going to be able to get my point across in 3 minutes. But I have a child support order here dated back from 2004. I was blatantly interrupted my child support payments December 2017 without a formal letter, for phone call or anything. So I called child support on the Flamingo office. I was told that there was a balance on the account and that they were keeping that balance because it was due to them from the father, which wasn't my problem. So I started to write letters. People started to respond. I wrote Carson City. I wrote the district attorney. I wrote to everyone that was addressed on the letterhead there, Flamingo Child Support. Long story short, since I only have 3 minutes, unbelievable. They sent me a bill saying I owe $740. I sent a certified letter from L. King. I guess if you're running a organization or whatever, you can use your initials. So she said that sent me a bill for $740. I wrote her a letter back. I received the green card, but I never received a letter back from her asking to resolve this matter. I don't want a bill hanging over my head. I would like this to be explained to me as an adult, as a taxpayer, as a community activist, as a voter, as a human being, as a woman, as a member that's protected under the constitutional rights. I deserve to get an answer on closure of this, because I don't want some years down the road and someone's trying to send me a bill with some liquidated damages or so on and so forth. If you just give me another 30 seconds, there's a Julie K. White, who is a resident agent of the Clark County Child Support, and this is her address that's registered with the Secretary of State. Is a physical address. So I guess Julie K. White has a home office, a home business contract with the state of Nevada, which I found odd because you never see those jobs plastered anywhere or in the newspaper. So they told me to mind my business about who Julie K. White is. If you see all this documentation, all of this is just recent documentation from the end of the year to child support, and there's probably some more at home. So this is what I have been sending them, and some of the response, even up to Carson City. So Julie K. White, I suppose, have all kind of personal information, Social Security cards, birth certificates, account numbers, everything you need to have that you have a child support order with Clark County collecting your arrears or child support. That is very prudent and valuable and important critical information. People's Social Security numbers, their kids' birthdays, your old addresses, whatever, no longer seem to be private because Julie K. White is running this business out of her home. I want to know who she is. So when I asked that, I was told
Thank
to
you,
mind
ma'am.
my
It's
business.
been
So
3 minutes.
so
If any
I
of
would
the,
like to- so-
ma'am, we'll ask the committee if they have any questions for you. I will make a statement just to make sure you are clear that this committee's job is to rewrite the child support statutes and the calculations. on the statutes.
Oh, well, you just got a
that-
lot of information to help you.
Okay, good. And this is not, so if you need a resolution of your own individual issue, I just want to make sure you know we don't have any authority over that. Our entire job is to rewrite how child support is calculated. And we don't have any other authority beyond that in this committee. So I just want to make sure you're clear on that and know that we will not be able to resolve your individual case or do anything with it within this committee. Does anybody on the commission have any
So maybe you can
questions
pass it on? Maybe
No,
you can pass it
ma'am,
on?
that it is not anything that we have authority over. This is a very neutral group of professionals that were brought together just to look at the statutes and determine if we needed to change the calculations. We don't actually have anything to do with your case at all, or any cases
Oh, I know you
individually,
don't.
so.
Right.
Okay,
I just happened to come here because there is no format. So when monies are stolen from accounts, you don't have anywhere to turn to. So when I saw this posted on the board, that's why I'm here today.
okay, thank you,
Did
ma'am.
anybody have any questions? No? I didn't think so.
Okay, next person?
Y'all need some diversity.
Yes, is everybody here listening? Are y'all oath?
Okay, first off, I need you to announce your name, and then I will
Oh,
start a
yes, my name
timer,
is-
and you'll receive 3 minutes, okay?
Yes, my name is Nina Dunn. I am a voter, and I understand that when you vote, the elective officials, they're saying that they're the people that we voted for, so they're representing us. And I'm trying to understand this child support. Child support is supposed to be something that, what y'all saying this is something y'all trying to do. It's the NRS code, revised statute, is to better it, right? Is this something that you're trying to better it? Okay. I'm here as a woman that you have a lot of the men's in prison. You have a lot of I'm here because of the prison men, the men's in prison. I just think that y'all revise this statute. It's a lot of women out here that's left because of the men is in prison. I believe the prison is getting like $300 per person a day, and I don't know why they're coming out of the system and still worried about paying child support. If the elective people are so worried about child support being paid, I think that would be a balance if the women was being paid out of that $300 a day to pay their child support. That way you got women out here and you don't have this big old thing as child support, because some of that money should be paying their child support. The women should not be suffering on the outside while the man is in prison, but they're making money off of them, but the child support is still lingering when they come out of jail. And that's what's keeping the people back, the men back, going back and forth in prison. And then when they get out, if they truck drivers or whatever, they get their license taken, child support and all this stuff. So it's not a better program that's being done. And that's why we keep getting the same results, because we got the same stuff that's going on. The reason why child support is lingering like it's lingering. This makes no sense for child support to still be lingering and the men is in jail making that type of money. That the system is making that type of money, $300 a day off of them, and none of this money is going to the child support. I think that some of that money needs to be going to the child support, so when they get out, they don't have that lingering over their head, and while they're in there, the women is not being able to survive without the man's child support. If you got him in there and he's working off his time, child support should, to me, be part of it.
Okay, thank you very much. We appreciate your time. Does anybody have any questions for her before she leaves us?
I do, Madam Chair.
Yes, sir.
I just want to make sure that I understand. You're saying that you think inmates, at first I think the $300 a day, you're probably misinterpreting the number in that's what it costs us to house an inmate. But are you suggesting that the inmate should be paying child support even when he's in custody?
Yes, I do.
All right,
I really
thank you.
believe that, yes. whatever it is, so the women won't be suffering while they're in there, and then when they get out, they still won't have that over their head, because that's what makes them say that we'll take your license, we'll do that, and then that's taking somebody's livelihood, and that's in the Constitution. The Constitution is saying no involuntary enslavement, so in doing that, you need to have them work and pay for their child support. That way, everybody is being covered. The woman that's left at home, she's being covered, her child support being done. When he get out, he don't have that linger on his head. To me, we need to make a system where you don't keep going back. Because why they keep going back inside the prisons? We need to stop this. You know, it should be a better solution to me. That's what I'm saying. I never been on child support. I always worked all my life. I never been in the system. Nobody never paid my housing. I never been on any of that. I've been a pipe fitter, and I worked all my life. But I'm just saying, when I'm sitting back seeing all these mothers crying out because of child support, my son's father paid his child support. He did what he's supposed to. He's a bridge builder. We never was in the system. But I'm just saying, I don't see the system working. The system is not working, and it's not going to work because the foundation is not built right. It's the Constitution that everybody swore an oath on, not commercial commerce and all this stuff. We got to make a better place for the women and the men when they go in there, and when they come out, they won't be in the same system going over and over. They need to be paying child support while they're in there, and they need to make a program for that.
Great.
And I just think so.
We appreciate your input. Thank you very much. All right, is there anybody else in Las Vegas that would like to give public comment?
No
On the
more.
phone.
Okay, hold on. Let me make sure there's nobody else physically in Vegas first. Are we good?
No, Madam
I
Chair.
can't really tell. Okay, thank you. Anybody on the phone that would like to give public comment?
Yes, I would.
Okay, please start by giving your name, and then you will have 3 minutes.
My name's Michael L. McDonald. I'm a candidate for Assembly District 20, the president of a Family Civil Liberties Union here in Nevada, Americans for Equal Prosperity, Restoring Freedom, and Veterans in Politics. I would like to address the committee and say that our system is in desperate need of overhaul. What Lisa was just describing is exactly what really needs to be addressed as well. I can tell you from firsthand that there's a multitude of men and women getting thrown in jail for child support. How are they supposed to pay their child support if they're in jail? I would advocate for relinquishing child support and for the committee to go to change the laws where they communicate to the DA is when they get thrown in, that their child support gets suspended until further court dates in the court. There's a lot of people getting thrown in jail for child support, and there is an influx of inmates getting thrown in where the system is making $200, $300 per day off of inmates, off of federal funding. So for every inmate that's getting thrown in, which right now our jails are full. I don't know if you guys are aware, but our jails and prison systems are full, and a lot of them are for traffic infractions or child support, and it's completely full of these people that should not be there. It should be an infraction. And then they go there. It's devastating families. When you have a system that's perpetuating putting them in jail for profit, and they can profit off of them, starving them and forcing them to eat food or purchase food or do 25 cents a minute or $1.20 for a ramen soup. So you guys, for your calculations for the base support for child support, I would say there should be a set standard of what should be implemented. Let's say for what both parents agree on. When parents can stipulate to what they believe can take care of their children, the system should honor that. And that's not being the case. It's like, oh, these are statutory minimums. We're not going to accept you guys' plea. Then we have a system that keeps going, keeps fighting endlessly because of child support. There's so many cases that people should be able to resolve their issues and doing through the divorce. But it's perpetuating the system because of the amount of money that's involved. When you have primary custody, you get paid, and it makes endless litigation and fighting because of that. For the amount of minimum child support, I would say the minimum should be set to whatever is capable of them paying. If they can't pay anything, how are they supposed to? If you set it to $50 a month, $100 a month, how are they supposed to pay it? They have no job. maybe there should be a means to put them through work programs or assistance for that, and then not setting a minimum when they have nothing or they're ending up homeless or on the streets because the family court's pillaging them of all their assets. As regards for modification of child support, you should automatically be able to modify child support whenever a job change or something like that occurs. And
Okay,
it should
thank
be
you, Mr.
communication
McDonald.
between the both parents.
We appreciate I said, thank you, Mr. McDonald. It's been 3 minutes. Thank you for your time. Is there anybody on the committee that would like to ask any questions? Seeing none, is there anybody else on the phone that would like to give public comment at this time?
Thank you.
Thank you. Anybody else on the phone? Okay, anybody in Carson City that would like to give public comment? Seeing none, we will close that agenda item and move to the next. Let's do approval. Oh, I'm going to take that back. Let's move back to public comment. I do have some written public comment I have to put on the record. I almost messed that up again. We had a meeting that was canceled due to technical difficulties. We could not get the system to work right. And we had public comment that had been submitted for that meeting. It was in the form of 2 emails from Colleen Fusillo, and she sent them on May 15th of 2018 and May 16th, 2018. And her comments were in the areas regarding additional child deviations and the healthcare issue and tax deductions for children. Those public comments are made available on and have been given to the entire committee and are made available on the DWSS website for anybody to read that would like to. Then we also received an additional public comment today, received today from Adam Radel, R-A-D-E-L, and his comments were regarding joint physical custody.
Hi.
Hello? Oh. His comments were regarding joint physical custody, the use of Wright v. Osborne, a request to include number of days into the calculation versus the type of custody, and a discussion regarding use of household income for the calculation and its impact on the payor when they live with somebody that also has income. That public comment is also available on the DWSS website to be read in full and has been distributed to the entire committee for use today. Okay, I will now close agenda item number 2 and move on to agenda item number 3, which is approval of the May 25th, 2018 meeting minutes. Do I have a motion?
Move to approve the
I'll move.
May 25th meeting minutes.
Okay, and a second?
I'll second.
All right, second from Dawn. Any discussion? Hearing none, all in favor, say aye.
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 Opposed, state
Aye.
nay. Okay, motion passes. Move on to agenda item number 4, discussion and recommendations on the proposed language for the base calculations for child support. As stated before, this agenda had to be developed before our last meeting, so it's really just a repeat of the agenda in order to accommodate the meeting being in such short course. But a new master document has been distributed to the committee, and I will bring up the fact that Judge Shirley had made a recommendation on a change of language to the calculation language on page 6. And the intent would be that this, the redlining in section 1 would be carried through to section 2, 3, 4, and 5. But I redlined section number 1 to represent the suggested change, language change that he made. He was not available today, but this was distributed properly, and so the committee can consider this change of language. If everybody's had a chance to read it, if not, take a moment, please. And it would read that, for example, for one child, the sum of 16% of the first $6,000 of a parent's gross monthly income, comma, plus. Just rearranging the language some. His concern that he expressed during the last meeting was that the intent that we had behind the section was not quite clear enough, and his hopes was that this edit here would make the difference. Do we have any comments on this?
Madam Chair, that was one of the suggestions that I had as well. So I think that makes it clearer, and I think it was consistent with what we talked about at the last meeting. And I have others if we're to that point in the agenda.
I believe we are. I was trying to do it a little bit along the lines. We could just go down to the master document and work on it first in the agenda. This was specific to the calculation in number 4. So if we could do this in pieces, that would be helpful for a clear record. So if we could do a motion to, and I'll do the motion just to be clear on it, a motion to make the edits that were provided on page 6 of 9, carry that through to the other sections as redlined in the master document. If I could get a second on that motion.
Second, Madam Chair.
Okay, second from Assemblyman Pickard. All in favor, well, any discussion? Hearing none, all in favor state aye.
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 Opposed state nay. Motion passes. Okay, to make it easier, let's just do that. Let's move down to agenda item number 11 for a review of the master document that we have in front of us, and let's work on some of those other individual edits. There are some others. I will state that the introduction provisions on page 1 were added. Those were the sections we discussed at the last meeting that were part of our prior statutes that are being repealed that we felt needed to be retained. Looking at the added language under introduction provisions before the stipulation and orders language, do we have any comments on that?
I do. That's,
Yes, sir.
In the second paragraph, second sentence starts, this presumption may be rebutted by evidence proving that the needs of a particular child are not met by the applicable formula. I would suggest that we include, so that the second half reads, are not met or are exceeded by the applicable formula, because we're talking about deviating either up or down. I think that would make it clearer for those reviewing it that you can go either direction rather than just one direction.
I like that change. Any additional comments or changes? Hearing none, I'd make a motion to adopt the language that is redlined in the master document under introduction provisions with the additional edit as stated by Judge Hoskin, where it will state second sentence of second paragraph are not met or are exceeded by the applicable formula. That's a hard word. Do we have a second to that motion?
Second.
I'll second it.
Kathleen Baker, second. Any discussion? All in favor state aye.
Aye.
Opposed state nay. Motion passes. Okay. Under the master document, I had moved around all the sections. I had made a decision to put the stipulations and orders ahead of the actual calculation for child support. The thought being just that's the precursor to if you do not come to an agreement, then the next step is to actually calculate child support according to the formula. that required me to add that sentence at the end of page 1 to kind of as the lead in between the two to make it make sense. If the parties do not agree to the amount of support required, the court shall determine, oh, there's the typo, shall determine, take out the determine, shall determine the amount of support according to the following guidelines. Do we have any discussion on that formatting of placing the stipulations and orders and adding that sentence? Mr. Sanford?
Madam Chair, I just wonder if we should have language, I'm looking under A through E, whereby the litigants also certify that the amount that they've agreed to meets the requirements of the child. That if we're requiring the court in the introductory provisions to set forth findings of fact, I think that an important finding would be that the parents certify that this meets their needs. Otherwise, the court would have to take evidence, as I read it, the court would have to take evidence as to the deviation. And I think that if they are required to certify, then that may be all the evidence they would need, but I'll let the judges weigh in on that piece.
Mr. Sanford?
I think that's a great idea. I was going to add something similar along those lines in that a court presented with the proposed stipulation of the parents for a child support obligation that does not comply with these guidelines may reject the stipulation, even if it complies with the requirements set forth above. If the court believes the stipulation is a product of coercion, I was thinking at the end of that sentence adding or not in the best interest of the minor children or something along those lines in case I don't believe coercion was the only reason to reject a stipulation if it wasn't in the best interest of the child. And my thought had been that it may not be sufficient to meet the needs of the children.
Is best interest the language we want to use, or do we want to use for something like that, Mr. Sanford, versus the language just regarding meeting the needs of the child? I get nervous as a private attorney who deals with custody when we intermix that language.
I would have thought that the best interest language was helpful just because that is sort of the governing standard in all of the family law situations, and I guess it could kind of cover situations that maybe we don't foresee right now, but I'll leave that up to the commission.
Madam Chair, if I can weigh in. While I initially liked the idea of sticking the best interest standard in there, in fact, I think we talked about that at a prior meeting, I think the term of art best interest may not be well placed in what we're trying to accomplish in this paragraph, so I think I agree with you with regard to that. I think that or does not meet the needs of the children would at least give the court sufficient ability to deviate or to not approve a stipulation under those circumstances. I think from a theoretical standpoint, best interest fits into that category. And I think for the same reason that Mr. Sanford wanted to put it in is the reason that I probably don't want to put it in, because we end up creating more havoc's not the word I want to use, but havoc's the one I'm coming up with when we've got to go look at a custody standard for best interest when we're really looking at a child support best interest, which I think, while maybe similar, are probably not entirely consistent throughout. So I'd suggest that we accomplish at least what I think you're trying to do with talking about the needs of the child or the children rather than throwing that best interest term of art language in there.
Any additional comments? Okay, do we have a motion? I'll make the motion. Okay. The motion will be to change subsection E under stipulations to include language regarding the parents needing to certify that the stipulated child support meets the needs of the child, and turn the current E into F, and then after coercion to insert or does not meet the needs of the child. And in the red line sentence at the bottom, correct the typo, take out the extra words, the determine. And that would be my motion. Do we have a second?
Second.
Second.
Kathleen Baker seconded. Any discussion? All in favor state aye.
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 Opposed state nay. Motion passes. Okay. Now on page 2, we have a big blank section when we deal with the actual custody language, determining who the payor is, but we'll move on. We'll skip that for right now. And I had, before the definition of gross monthly income, added an introduction paragraph, kind of trying to lay out the steps, because we tried to turn it into actual steps for calculating child support, and added the following language. That first, typo with a capital T, we'll get this correct at some point. First, the court must determine the amount of gross income of either party, either by stipulation of the parties or court determination upon consideration of all relevant financial information or other information relevant to the parent's earning capacity. The court may direct either party to furnish financial information or other records, including income tax returns for the preceding 3 years. That is the current language from one of the statutes that's being repealed. I just plucked it out and placed it in. I highlighted the 3 because I thought it was worthy of a discussion amongst the committee, because that is the old language, and whether or not that should be updated or changed or made a little more broad for what the court can do or necessitate, so that an argument can't be made that it can only ever be 3 years. But any discussion?
Madam Chair?
Yes.
The concern I guess I have in the first sentence of that, I like the fact that we're dealing with it in a preamble way. It appears as though that the court must, we start off with the court must, and I think we're leaning towards having parties be able to do this themselves. So my suggestion on that sentence is that it says first, and then skip over, the court must determine it. So it'll say first, the amount of gross monthly income of either party either must be determined by the court or by stipulation of the must be determined either by stipulation of the parties or court determination. So we still have stipulation and court in there, but we don't open the sentence with that the court has to do it. So my suggestion is that we take out the court, the capital the and capital court, and start the sentence with the amount of gross monthly income of either party, there's too many either's there, but I don't know how to pull that out. Of the parties must be determined by, is the insertion there, and then go to stipulation of the parties or court determination. In my mind, that gives clear direction to parties that the court doesn't have to be involved at the outset, and they can take matters into their own hands rather than have to be reliant upon the court.
Keith Pickard for the record. I agree with that, and frankly, I think we can drop the word either entirely from this paragraph.
And I'm happy to talk about the 3-year part once we get past this.
Okay. Any further discussion on that? Mr. Sanford?
I know we've talked about this a couple of times, about calculating both parties' income or receiving income information from both parties as being sort of a detrimental effect on the 4D program. So if we could maybe clarify that it's the payor parent, or determining the amount of gross income of the payor. Just resolving that so that we don't have we frequently have issues where we have to explain to a payor parent that the income of the other party is not always relevant, and I would hate to have something in the statute that says, but this says you must.
Kathleen Baker for the record. I'm not certain, I understand the dilemma for the 4D program because we often can't get financial information from both parties, but I find that especially we want to be careful, we want to make certain that we have that income available if we have a shared custody arrangement. I also think that there are times when we may have a relative income issue, and we can't really look at those particular issues without having the income of both parties, which we frequently don't get anyway.
I think my response to that would be if we say the income of each payor, but we're very careful in the determine who the payor section is, and when it's a shared custody, that we're still calling them both payors, because they are both payors. It's just a matter of what's the net amount that actually gets paid out. That maybe that'll cover that, or am I missing something?
I think that that's a great idea, or I mean, we can play with how we want to define it. I think that calling them both payors in our definition section, just something to ensure that in this section we're just calculating gross income of anybody who's going to be a payor, either in a split situation or a shared custody situation. That would be both parties, and in a primary visiting situation, it would be the, I guess, obligor, I guess, is what we have typically used, but it could be changed throughout.
So the suggestion would be, that would read, first, the amount of gross income of each payor must be determined by stipulation of the parties or court determination upon consideration of all relevant financial information or other information relevant to the parents. We could probably change that to payors, earning capacity, right?
Madam Chair, I would suggest that we stick with obligor because, as Mr. Sanford suggests, if we're talking about a net, only one person is actually paying, and that might be confusing. However, as I recall, we've established somewhere that both parents are obligated to pay, so they would both be obligors.
Well, what just caught my attention too is it's not always a parent that's paying support. So I have many other circumstances and worlds that we work in these days, financial or family circumstances. So, okay, so obligor is what I'm hearing instead of payor and instead of parent. Okay. Let's talk about the 3-year part of that, unless we want to do that, break this out into 2 motions, but I don't know that that's necessary. Do we have comments about the 3 years of returns?
Yeah, it's Judge Hoskin again. It is permissive. It's not mandatory. It says the court may, and I'm okay with the may. But if we don't want to run into the preceding 3 years, my suggestion is that it would be income tax returns for prior years, and leave it to the court to make a determination whether that's 1 year or 5 years. And there are some circumstances where you'd want more than just 3 years. So I agree that I'm not sure we want to be limited to 3 years, although I don't know that I want to limit it at all, because I think circumstances are different from case to case, would be my suggestion.
Additional comments on that? Okay, so I would make a motion that we adopt this language with the edits as discussed on, well, I'll just read it as it should turn out. First, the amount of gross income of each obligor must be determined by stipulation of the parties or court determination upon consideration of all relevant financial information or other information relevant to the obligor's earning capacity. The court may direct either party to furnish financial information or other records, including income tax returns for prior years.
Kathleen Baker, I would make one other suggestion, which is that the gross income of each obligor must be determined by stipulation of the parties or by the court.
I like how that reads better because there's too many determinations in that sentence.
Yeah, I agree. Okay. Or by the court. Okay. Do we have a second to that motion?
Second.
Second.
All in favor?
Aye.
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 Opposed, state nay. Okay, motion passes. Okay. On page 3, this was language we already approved for removal, but it just made it finally into the master document in the right order to remove the language regarding childcare and health care from the gross monthly income language definition, and that's all that happens on page 3. And I don't know, unless there's an additional edit or a change needed to it, it is something that we've technically approved, but.
Kathleen Baker for the record. I just have a question. In looking at this document, I looked at 12D, which talks about public assistance as being not included in gross income. But then on page 7, when we look at adjustments, it also talks about public assistance being used as a deviation. It's public assistance paid to support the child. I have to tell you, I'm unclear as to the difference between those two public assistance definitions, and I think it would be important to clarify.
Additional comments? Let everybody.
I'm sorry, I'm getting feedback and I'm thinking somebody else is talking. I think they're different, and somebody can clarify for me if I'm incorrect on that. I think that if it's the obligor's gross monthly income we're looking at, then we want to be able to deduct that from the gross monthly income. If it's the obligee that's receiving the benefits, then the court has the ability at that point to adjust based upon that. I don't think they conflict, although I am a little concerned because we keep talking about simplifying instead of making more complex, and I agree with Ms. Baker, this couldn't be confusing, but at least that's my understanding of what we've tried to do with that.
So would it be helpful under 12D to actually state public assistance benefits received by the obligor?
It may be, although I'm not sure it's necessary because it doesn't matter. Sorry, I'm trying to think out loud.
Me too.
We don't care. Care's not the right word. We don't calculate benefits that are received by another party in the other party's gross monthly income. So I think it's presumed that way. But again, for sake of clarity, it may not hurt. My only thought would be that we perhaps need to include that.
But that clarifies
Addendum.
it's not the child benefits, at least.
Well, perhaps then rather than putting it in D, we include it in the right after 12, all other income of the obligor, whether taxable or not, does not include any of the, well, and I don't know that we get there either. But most of A through I, I'm presuming are obligor's numbers rather than obligee's numbers, or else we wouldn't be utilizing it. So if we include it in one of the sections, I think it may cause some confusion. Are we including it in all, or do the other ones we can actually look at the obligee rather than the obligor? Is my only concern with narrowing it down that way.
Maybe it's the first intro part of 12 before the enumerated sections that we clarify
Madam Chair.
all other income received by the obligor? Yes, Assemblyman
Keith
Pickard.
Pickard for the record. Thank you. I think that's probably a good idea because when we're looking at, and I think the reason we included this was because this is, these are issues that we've run into when we're trying to figure out what income is going to be included in the calculation. And so if it's a joint physical custodial arrangement, both parents are involved. If it's a primary physical custodial arrangement, only the non-custodial parent's income is involved, at least at this part of the calculation. And so if we want to make this clear, I think putting it right up there in the introductory portion of the paragraph makes a lot of sense.
But while I agree with Assemblyman Pickard and write that down for the record, I'm not sure that solves Ms. Baker's concern, which is where we started on this.
If I may, Keith Pickard for the record, when we look at item E under step 5, it does say any public assistance paid to support the child. And so I think that is sufficiently clear to indicate that this is public assistance that's paid ultimately for directly to the benefit of the child, where a non-custodial parent should not be receiving that.
Ms. Baker?
I think with clarifying on 12 that it's the income of the obligor, I think that that's going to help out considerably, at least from my perspective.
You want to make a motion?
I would make a motion that we modify number 12 on page 3 for the first line to say all their income, whether taxable or not, except that gross income of the obligor does not include any of the following.
Second?
Second.
Okay. Assemblyman Pickard, second. Any further discussion?
Yeah.
Yes.
And I'm sorry, I'm trying to think and listen at the same time. Perhaps, and for consideration, that the obligor portion be included at the very beginning, all other income of the obligor.
That's where I had initially made my note, but I just changed it, but yeah.
And I'm trying to articulate why that makes more sense to me, and I can't tell you why. I'm sorry. It just, to me, it seems more clear that we're talking about all these for the obligor if we put it there than further down the sentence. But from a grammatical standpoint, I can't explain that. So
I would move to adopt Judge Hoskins' change of all other income of the obligor.
Okay, Assemblyman Pickard, you were the second on that motion. Do you accept that?
I'll concur.
Okay. Any further discussion? All in favor, state aye.
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 Opposed, state nay. Motion passes.
Madam Chair?
Yes.
Something just occurred to me, and I don't want to forget it, so I appreciate the indulgence. One of the things we want to be careful about as we consider the language is whether or not we're going to allow LCB some latitude in adjusting the language as they put this in codified form for us. If there's any doubt as to how much latitude they have, we need to make sure that we are really solid with our language, because that will constrain them pretty significantly, I think, if they run into something that they think needs to change. So as we approach the end of this, I would suggest that we consider how we're going to address recommendations that they make. That was all. Thank you.
Okay, thank you. All right, let's move to page 4 under imputation of income. in looking at the statutes that were being repealed and the language that was being repealed, the old language was part of the repealed language. We had decided to include that nice, clean, lengthy factors list for imputation of income, but we didn't have the intro language on that. I did make a suggestion myself for suggested language change to the old language. The old language is, if a parent who has an obligation for support is willfully underemployed or unemployed to avoid an obligation for support of a child, that obligation must be based upon a parent's true potential earning capacity. My suggestion was to change it to, if a parent who has an obligation for support is willfully underemployed or unemployed, the court may impute income. My basis for that also comes from public comment that we've received over this process, and also just my acknowledgement within my own cases and my own experience of the frustration of how hard it is to impute income when you have to actually prove that the reason they're underemployed or unemployed is for the sole purpose of avoiding their obligation of support, child support. That's near impossible to prove. We rarely can prove it. And I think it's a huge obstacle to giving the court that latitude to make right-sized orders and do what is actually needed for children, keeping in mind we still have the adjustment, or the language regarding ability to pay is still supposed to be a key element. I may be overstretching it with oversimplifying this, but I'd like to have the discussion because it is part of the old statutes that we need to consider.
Keith Pickard for the record.
Yes, sir.
This reminds me of some of the conversations we had back in 2015 as we were addressing some of the factors going into relocation. And one of the principles that we kept coming back to was due process and making sure that we don't circumvent that. My concern here is that this is so abbreviated that it might be viewed as a mandate, if not guidance, to find willful underemployment or unemployment if a party is not employed. There may be legitimate reasons for that. So I would suggest that I like where you're going with this, but I would suggest that we add some language to the effect of if the court determines after notice and hearing or something like that that a parent is willfully underemployed, the court may impute income. That way it's clear that if we're going to impute income, there needs to be at least some level of evidence taken. That's my thought.
Judge Hoskin, for the record, just a couple of stylistic suggestions. Consistent with what we've done in other sections, rather than a parent, change that to an obligor, because as you've indicated, it could be somebody other than a parent. And then at the very end of that sentence, may impute income to that obligor, just for clarity. And I'm not opposed to including if a court determines that an obligor who has an obligation for support. I think we'd probably need a couple of commas in there, but I don't have a problem with that language. I think it still gets us closer where we need to be and eliminates that need to find that it's unemployment for the purpose of avoiding child support, which I agree is a difficult standard to meet.
Additional comments? Okay.
Keith Pickard for the record. I'm just curious if anyone else agrees that we should suggest, taking evidence before that determination, because we've done that elsewhere, and I personally think that's important, but I may be the only one, and I don't want to hold this up for that.
I have no problem with that. I think imputing income is something that needs to be taken serious before it's done, which is also the reason for the the language about if you are going to impute, it's got to be based on all of those factors. I think it's just as important, the decision to impute is just as important as how to impute, and we've laid it out very specifically what the court must take into consideration to calculate that imputed income. I think it's just as important on the front end that they have to work just as hard in order to impute it. I don't mind working hard on it. I just think that the prior standard is just near impossible. I mean, it's really hard. Courts will do it still, but I mean, really, when you look at it, to have to try to prove, that they're underemployed just for that reason, there's a million excuses. But, I mean, courts see through it. They make that determination, but it's a hard determination. I don't think it's flexible enough.
No, and I agree. I think that we should relax that. I think too many obligors get off without, that's the wrong words, but they're not obligated to pay what they should simply because the other side hasn't obtained the right information, the right evidence to present when it's pretty clear to everybody that the person can work. But I just jump back into 125 C0035 just for a sample, but it says, and we've used this in many places, but a determination by the court after an evidentiary hearing and finding by clear and convincing evidence that, and then whatever it is. I wouldn't suggest we need clear and convincing evidence on this one. I think preponderance of the evidence would be fine, but that's language that appears in several other places in the statute. And so I would propose that we insert that, that we insert a determination by the court after an evidentiary hearing. And if we want to go ahead and say, and finding by a preponderance of the evidence that an obligor who has an obligation for support is willfully underemployed, and so forth.
I don't know if we need to go, my thought was also more along the lines of just like our other requirements that we have elsewhere in the statutes, that if we change the standard to just state it needs to be based on a specific findings of fact, then the court, without having to set the getting into presumptions and standards, it's just that it's going to be specific findings of fact. I don't know. Thoughts?
How
Mr.
about
Sanford.
if we,
Oh.
I'm sorry, Mr. Stanford, go ahead.
I had one, I guess, concern with removing the language. I agree I've had a number of cases attempting to approve that it's to avoid the obligation of support, and that is very difficult to do. I guess I'm just trying to think of what we would want to do as a protection for, or guidance for courts that are in a situation where the willful underemployment or unemployment isn't for the purpose of avoiding child support, but is, for example, taking care of a sick family member, or going back to school or something like that, that they might consider a reasonable purpose. I understand that it says the court may impute income, but I'm just trying to think of if we want to provide some guidance of when we would want that to be done that isn't when it's for the purpose of avoiding the obligation of child support.
In trying to give some middle ground between what was proposed and what Assemblyman Pickard suggested, I would suggest if the court determines after taking evidence that an obligor who has an obligation, which gives us the opportunity for taking evidence, we're not providing what standards should be used, and I don't know if that makes people uncomfortable or not. And as to Mr. Sanford's point, if you want to give the court more guidance, I don't know that I would be opposed to that, but it does have perhaps an unintended consequence with regard to that as well.
Kathleen Baker for the record. Perhaps this next paragraph, that talks about what the court must consider. We could add that the court may also consider the specific situation leading to the obligor's unemployment or underemployment.
I like it.
Meaning because they were willful,
Because they're taking care
it's
they're taking care of a sick parent, or there's some reason that a legitimate reason that they are underemployed or unemployed that would militate against imputing income. So add that as a factor for consideration.
on the calculation part of it. Because we start that paragraph with if imputation of income is authorized. So we have to come up with the language about when it's authorized. That's why I was worried about getting the first paragraph in. This is all about how much the imputed income is going to be. And I agree. I mean, I don't have a problem with that, though, that the amount of imputed income can be adjusted because of the fact that because of what the reason was for the willful, but we still need that initial step of deciding that that imputation's authorized. I think when we saw other statutes too, we did see some language with other circumstances in which courts would impute income. Ours was so narrowly drawn to that specific incident of willful under and unemployed for avoiding child support versus when we look at the federal rules, one of the biggest concerns was just if you do authorize it as a state, when you do, you need to take all these factors into consideration. It's just we still have that latitude on deciding when we're going to allow imputation of income. Do we want, as a policy, as a commission, to broaden that to make it easier for the courts to make those decisions on when they're going to impute versus not, versus keep it extremely narrow and tight like the prior language that we had?
Madam Chair,
Yes.
I like where this is going, but I'm going to take a couple of things kind of out of order. First, in that second paragraph, for it to read, if income is imputed, the court must take into consideration. But then Ms. Baker's suggestion, I think, would have to come before that paragraph. Because I think it's perfectly legitimate to give the court the ability to consider why a person is unemployed. I agree with Ms. Baker and Mr. Sanford in that respect, because there are instances where a mother may decide to work less because she thinks she can live on less in order to provide care for a special needs child or something. And so there are probably multiple reasons that we would not impute income under certain circumstances, but that would have to come before that last paragraph. So I would suggest we figure that out in your suggested language and then change the second paragraph.
What if it said something, and this may be the complete wrong word choice, so just bear with me. If the court determines after taking evidence that the obligor is improperly underemployed or unemployed, or something along the lines of, that's that, or just the willfully. I don't like just willfully, because they may still have they're willfully unemployed for the purpose of taking care of a sick parent, or, whatever the proper reason is. So willful isn't an appropriate word choice by itself. But something along the lines of improperly or inappropriately underemployed or unemployed, the court may impute income to that obligor. Unjustified. You have to have your mic on.
I was thinking unjustifiably, but I'm having a hard time with the adjective to use.
I am too, but I think it gets us closer to that whole, the court's able to assess the reason for it.
Madam Chair, we just had
and
a
make a
quick
decision.
sidebar.
Uh-huh.
I'm sorry, what if we just said, for support is willfully and unreasonably underemployed or unemployed? Our first reaction was, well, then we get into that reasonableness argument, but that is kind of we're giving the court some space there to make a reasonableness determination. And that way we don't have to so narrowly define it. It was just a thought that bounced around down here.
Kathleen Baker, another thought might be without good cause.
Oh, that's good language, too. Thoughts on that?
I think
Judge.
we're all nodding down here.
So if the court determines after taking evidence that the obligor who has an obligation for support is willfully or is underemployed or unemployed without good cause, the court may impute income to that obligor.
We're unanimous down here. In favor, I should say.
Okay, let me write it out so that I don't lose what the motion is going to possibly be here in a minute. Willfully, or is willfully and, no, we're getting rid of willfully. Is under or unemployed without good cause. Okay, so I'm going to make a motion for the language. We're going to strike the old language and place a paragraph before our prior language that we already placed for calculating imputation of income. And it will state, if the court determines after taking evidence that the obligor who has an obligation for support is underemployed or unemployed without good cause, the court may impute income to that obligor.
Second.
And then also in the second paragraph, it'll state, if imputation of income is authorized, the court must take into
Madam Chair, no.
consideration.
It was if
No?
income is imputed, the court must. If income is imputed, comma, the court must take into consideration.
Okay. Imputed. Okay. If income is imputed, the court must take into consideration the specific circumstances and then all the prior language we had. Okay. Do we have a second?
Second.
Kathleen Baker seconded. Any further discussion? All in favor state aye.
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 Opposed state nay. Motion passes with the edited language. Okay. I hope I edit it right for next time. All right. Step number 3, medical support. We have a sentence there that was proposed by Assemblyman Pickard, and I know that he and Judge Hoskin had additional discussion about that language and already have edits, and I'll let them propose that.
Yeah, with all due respect to Assemblyman Pickard, I made some changes that he actually agreed to, so I appreciate that. So I'm proposing that the sentence reads, that first sentence there that's in underlines, the court shall consider the reasonable costs of health insurance premiums and the reasonable child care expenses paid by either or both parents and shall make an equitable division thereof.
Second.
Any discussion? Do you need him to read it again? The court shall consider the reasonable costs of health insurance premiums and the reasonable child care expenses paid by either or both parents, and shall make an equitable division thereof. Any further discussion?
For the record, this is David Castagnola. I do have a concern regarding the draft medical support language that I'd like to review.
Okay, so
If this
underneath
is-
medical support considerations?
Correct.
Okay, so let's do this initial sentence and then.
Come back.
Yes,
All right.
and we'll do that as the next issue. Okay, all in favor, state aye.
Aye. This is Dawn Throne. I do,
Yes, Don?
sorry, I do have a comment. If we're going to say it's mandatory to split the cost of the premium 50% below, then doesn't this conflict?
It says equitable, it doesn't say equal.
But we need to address that when we get.
Well, we've got to, we do need to talk about the next section, so if we're okay with this sentence, we'll start with it, and then we'll talk about the next part. As David stated, he had a concern for that, too. Okay. We had discussion. All in favor state aye.
Aye.
Opposed state nay. Motion passes. Okay, David, do you want to start us on your issue with the medical support considerations?
As I understand the draft language, medical support is expressed completely in terms of a cash or a monetary requirement, and there is not a requirement for one or both parents to enroll the child in health care coverage if it's accessible to the child, reasonable in cost to the obligated parent, and available. And I believe that that does not fulfill the federal guideline requirements in 45 CFR 302.56. OCSC, the Federal Office of Child Support Enforcement, interprets that guideline requirement regarding medical support as a first option to enroll the child in health care coverage. And then if it is not available, accessible, or reasonable in cost, then go to a cash equivalent.
Do you have a proposed edit to the language to get us there?
I would need to work on that, but I think a sentence requiring to first look at health care coverage. And I also want to add that I think it's particularly important now because under the Affordable Care Act in 2019, the individual mandate goes away. So there's nothing that requires a parent to enroll the child in coverage.
Okay.
You can require them to pay for it, or you can give them credit for paying for it, but what's going to make them go out and get it?
Okay. Can you work on language for that? And when you sit in or Nova sits in, bring that language forth at the next meeting?
Yes.
Okay, thank you.
Madam Chair,
Uh-huh.
just a question that I have, is it within our purview to mandate that according to federal law, or are we simply supposed to deal with the cost thereof and how it affects child support? I'm just wondering if we're overstepping with mandating such coverage.
I think that requirement for health care coverage is in the federal guidelines for, is in the federal requirement, the federal regulation for what guidelines must include. And then also AB 278 repeals 125B 085, which is the medical support provision. So I'm not an attorney, but I think there is authority for the committee to address that.
I agree. All the specific language on the medical is repealed, yeah. And we need to either replace it or modify it. Ms. Throne? Did you have a concern?
Did you have something?
Well, the language we have already approved does say that the premium cost is divided equally between the parents. So how is that consistent with saying make an equitable division thereof?
That is one of the edits we have not made yet. That's why at the time when we were dealing with it within in a bubble, based on just the medical support language, this is what we had come to. Now that it's a package deal with everything else we've done and it's part of the master document, we need to consider whether or not it needs to be edited to reflect our decision on the equitable division.
Madam Chair,
Yes.
did anyone else join us? Are we strictly at a quorum? Because I have another obligation I'm supposed to be to, and I don't want to abandon the committee if it's going to kill the meeting.
If we started with a quorum, do we have to maintain the quorum? We have to maintain the quorum. Do we have anybody on the phone that is part of our commission? Nope. We need you for a quorum. But you have court, correct? You have
I
a
do.
hearing? Yeah. And do you need to go right now?
I can push it probably another 5 or 10 minutes and still be safe.
Okay. Oh, we have to do public comment too.
Madam Chair,
Yeah.
we don't need a quorum for public comment, I don't think, do we? That wasn't my
Our
comment.
deputy AG is recommending that we keep the quorum for the public comment.
Okay.
Okay.
What I was going to say was, I think that the discussion in previous meetings, plural, was that we were going to move away from a 50-50 defined split and allow the court discretion to do an equitable division under the circumstances of the case. So I would suggest that the paragraph, fourth line down, starting with the cost of medical support shall be borne equally, that entire sentence be deleted.
Mr.
In fact,
Sanford?
it might make sense to move the first sentence, replace this with the first sentence we just approved.
Okay. Mr. Sanford?
I don't know about our federal auditors. They sometimes have different opinions than I do about what a deviation and adjustment or whatever we're going to call it is. I'm just trying to consider whether or not, if we say it's an equitable division or something like that, is that still going to leave us in a situation where every order with health insurance premiums and child care is considered deviated? I really don't know the answer to that. I'm just trying to consider whether there is a difference between providing a presumptive amount that can be deviated from I guess we had in extraordinary circumstances the last time, and then having that be the standard with when an extraordinary circumstance happens, having that be considered the deviation, or if the federal auditors don't think that it's a deviation, if we just leave equitable division in there, then I think that is generally better, but
I don't think it is because of the word shall. When you tell the court and when you calculate child support, you shall consider medical and it shall be part of the formula. That changes things from you may adjust your end support amount for these following reasons on your own discretion.
I'm just considering whether
And,
that's... Go
sorry,
ahead.
Go ahead. All right, I was just going to say that, well, first, Judge Hoskin agreed with me again. I want that on the record. And, but when we're talking about extraordinary circumstances, those are subsumed within the context of an equitable division. The court, when it's considering an equitable division, it's looking at the circumstances, extraordinary or otherwise, and so I think that it adequately addresses that. But I have no idea what the feds would do with this. But given our effort has been to eliminate deviations, my guess is, on balance, this one may not have a significant effect, but we would have to talk to them, and I don't know that there's really time to do that.
Okay, so for,
Ms. Dawn Throne,
Yep.
the problem with making this equitable division is equitable doesn't mean anything when you have all the different judges and hearing masters in the state all doing something different. If we lose the 50% of something that's essential, medical insurance coverage, you're going to have different people or different decisions made for people in the same circumstances throughout, depending on where they are in the state and who's making the decision.
And I agree with that. One of the things I've been trying to do as I address all these things is look at how can we give sufficient guidance so we don't have widely disparate rulings. But I've had just recently several cases where there's a significant disparity of income. I have currently one case where mom is disabled, has $1,800 a month in disability payments. Father makes upwards of $15,000 a month, and the the insurance premium for the child is about $700. So if we were to force, in this case, my client to assume 50% of the cost of medical support, there's, obviously there's the extraordinary circumstance, but again, I think that the equitable division is exactly what I would like to do in terms of giving discretion to the court, and I'll leave it at that.
David, you had a comment, or?
Yes, I don't believe that it would be an issue with the federal auditors. As far as medical support, there's a numeric requirement for defining reasonable, which that is addressed in here, and medical support needs to be addressed, period. But other than that, the federal auditors are not going to look at that detail. Deviations can occur. They just need to be minimized and standardized where possible.
Okay. All right, well, considering we will be losing Judge Hoskins soon, do we have, perhaps we table this for now? Yes.
I'm sorry, Madam Chair. The other comment I wanted to make was the phrase, "in other words." I don't recall ever seeing that in statute before.
Where is that?
Second line down. In other words, the obligation for support, we don't need in other words. That's
Oh.
my thought.
I'm assuming that came from some of the federal stuff. I don't know where we got that from. But, okay, why don't we do this? I will take a shot at editing based on some of these comments. And next time we will review it again on the agenda. And with that, and knowing we're going to lose our quorum, let's immediately jump to public comment. Is there anybody in Carson City that would like to give public comment? Seeing none. Anybody on the phone that would like to give public comment?
Yes, ma'am. I would like to give a comment. My name is Sharisa Tilley.
Okay. You have 3 minutes. I will cut you off at 3 minutes, and you may begin.
Okay, I'll try and keep it short. I'd like to see something in the statute regarding the garnishment of wages. This is because of a case that involves my husband. His name's Jared Tilley. He hasn't been able to get the reviews he's requested for the DA's office through the call-in line, even though he's had multiple changes in circumstances. They haven't provided him with audits when he's asked. And I know there's also a law on the books with regard to Medicaid case enforcement that states that you can't garnish someone's wages if they're receiving Medicaid. He's been a victim of having his wages garnished even while he was receiving Medicaid. So I just would like there to be something on the docket to discuss more oversight when the DA's office is garnishing wages to make sure that there is a valid order in place and a route for the obligors to request a review and receive the review promptly.
Okay, thank you, ma'am. I will comment that we are under a very strict bill from the legislature. It's called AB 278, and you can find it on the DWSS website. It gives us our authority for what we can and cannot review and change. And this commission's only been given authority over the calculation of child support, nothing having to do with garnishment. of wages or any of the enforcement provisions through the district attorney's office or the Department of Welfare and Social Services. So I'd love to be able to assist you with that through this commission, but we don't have the authority. The legislature didn't give us the authority over that. The legislature would be the proper place to go for that.
The legislature. Okay. Thank you very much.
Thank you. And do we have anybody else on the phone that would like to give public comment? Hearing none.
One quick
Is
comment.
there anybody in Las Vegas that would like to give public comment?
One
No,
quick
Madam
comment.
Chair.
Okay, hold on. Is there somebody on the phone?
Yes, ma'am.
Okay, you have 3 minutes. You may start.
This is Michael McDonald for the record. I'm the Lord candidate for District 20. In regards for Hopkins leaving, I'll be brief. In regards to calculating medical and daycare costs, I would say that you should give the power to the parents and do whatever they stipulate to. Give them the authority to discuss and to come up with options that the judge should take into consideration when dealing with medical. Let's say one has Medicaid or one has a plan through the school. You should be able to stipulate if both parents say, hey, I'm not going to go after them to provide half the support. They should be able to stipulate to that, and just making sure through any of the laws that you guys discussed that you give that parent that authority to the parents instead of the judge, so that we don't have cases where they're getting imputed or charged or thrown in jail for frivolous reasons. I would make sure that you guys add that, and thank you.
All right, thank you, Mr. McDonald. If you'll look at our master document, we do have some very good language on stipulations that we're proud of and working on at this time. Do we have anybody else on the phone that would like to give public comment? Okay, hearing none. Anybody in Las Vegas in person that would like to give public comment?
There's no one here.
Okay, thank you. I'll take a motion to adjourn.
So moved.
Second.
Second.
All right, all in favor state aye. Aye. Opposed, nay. Motion carries. Thank you.
Nay.